Good morning, everyone. Happy Monday. I am Carol Williams with Williams Immigration, and we are back for another Monday morning edition of Beyond the Soundbite, where we talk about all things U.S. immigration. So, I like to dive right on in. First thing I want to talk to y'all about this morning are green card holders and international travel. If you are a green card holder, we have seen a lot going on in the news recently. Should you travel? Can you travel? What should you do? What should you not do? So for a lot of folks, the answer is, can you travel? Yes. But for some of you, the answer to should you travel, even though you have a green card, is it depends. And it depends this week, last week, on whether or not you've got any criminal history to speak of. So, and by criminal history, I mean anything, especially inside the US, but also outside of the US. And do you have a criminal history that was evaluated prior to getting your green card? Or do you have a criminal history that has not at all been evaluated by the Immigration Service? Maybe the Immigration Service doesn't know about it because maybe whatever happened after you got your green card. So if you have any criminal history to speak of, again, whether it was before the issuance of your green card or after the issuance of your green card, I highly recommend that you speak to an immigration attorney before you travel internationally. Over the years, I've spoken with people who have told me, they've called me and they've told me, well, I have a criminal history, but it's not a big deal. Or they say, well, the judge dismissed my case, so I don't have to worry about it. And let me be super, super clear. Any criminal history can be a big deal when we are talking about an immigration benefit. Whether we are talking about being granted a green card, whether we are talking about being granted U.S. citizen, and now we are seeing prior criminal history become an issue when you are traveling back into the U.S. So if you have any sort of criminal history before you book flights, before you plan a vacation outside of the U.S., please have a conversation with an immigration attorney so that an analysis can be done on what we think will happen when you are trying to re-enter, or whether or not your criminal history will potentially impact your current green card, whether your criminal history will potentially impact a U.S. citizenship application. So just know that if you have a criminal history, just know that you really should be having a conversation with an immigration attorney. So the second thing I want to talk to y'all about are also related to green cards, but this is more of a USCIS, so you're inside the US issue. If you are applying for your green cards, USCIS has now been directed, there's a new policy in play. They have now been directed to issue notices to appear, which are also called NTAs, which is the beginning of the deportation process. They have been now told, and is now policy, that if a green card application is denied, that a notice to appear should be issued. So two things sort of come out of this memo, the way that I think about it. One is, it is really critical to have solid and good documents when you're applying for your green card. I talk to people about that all the time. When I go live during the evenings, I talk about having really good, solid documents. So I cannot stress enough having really good documents so that we can get you that approval. The other thing is while you're applying for your green card, maintain your non-immigrant status. So maintain your underlying status. For most of my clients, many of my clients, that underlying status is going to be, let's say, an H-1B or an L1 or an O1. Maintain that status so that if your green card for some reason is denied, you still are here in the U.S. in status. That's a game changer. And I think that's going to be a game changer for a lot of employment-based green cards where people and companies get together and they decide, well, they're just going to let the H-1B or the L-1 go, and they're going to work based on the work authorization and the travel permission, and the travel permission that they get that is connected with their green card application. So right now, it's crucial to really maintain your underlying non-immigrant status if you have that to maintain. But the now new policy is that the Immigration Service, if a green card is denied, they have been instructed to now issue NTAs. The next thing we're going to talk about this morning is there is now, so we've been hearing in the news and on social media that there's registration is required for individuals that are in the US and are undocumented. And so we have a new interim final rule that essentially says if you are here in the US and you are undocumented, then you are to sort of affirmatively present yourself and register as an undocumented individual with the US federal government. So this new rule goes into effect on April 11th. But it's an interim final rule, so comments can still be sent into the Immigration Service, and they're accepting comments until May 12th. So if you feel strongly about this rule, feel free to write your comments to the agency, and they do look at the comments, and they do take them into consideration when they are looking at rules and whether or not they need to tweak the rules for whatever reason. So this new registration policy is for people that are undocumented. So let me tell you who the rule doesn't apply to. That will sort of help you figure out if maybe you are one of these folks that will ultimately be required to register. So the rule does not apply to individuals who entered the US with a visa. Doesn't matter what the visa is, just as long as you entered the US with a visa. So it could be a visitor's visa, it could be an H-1B, it could be a student visa, it could be an L-1, it could be an O-1 visa. But if you entered the US with a visa, if you are a current green card holder, or maybe you entered the US with an immigrant visa that you got at the consulate and they stamped your passport with an I-551 stamp and your green card, your physical green card is coming in the mail, you do not have to register under this new rule. You also don't have to register under this new rule if you received an employment authorization document, which we shorten to EAD. If you have a border crossing card, or if you have been issued an I-94. Now, for the I-94, that's only issued online. And so if you've listened to me for any amount of time, you know that every time you enter, you should be going on to that I-94 website and pulling down your I-94 so that you have it. It contains very valuable information. The most important of which is by what day you need to leave the US, right? So you always want to know what your I-94 is. So that is a list of people. If you fit into any of those categories, those are people that do not have to register. So essentially, we're looking at most other people are going to have to register. So that is people that are here without status. So we will keep you up to date on that, what that looks like. If there are any kind of changes after the comment period is over, we will keep you up to date on that. CBP has launched a mobile app, CBP Home, that has a new departure feature so that you can essentially log into this app and tell CBP, tell the federal government that you are intending to leave the US. I have not personally looked at the app, so I can't tell you how easy or how difficult it is to use, how intuitive it is, nor have I heard of any of my colleagues logging into it or their clients logging into it yet. So I don't have a ton of information about the app, except that it is out there. So I will keep you posted on that as well. The next thing I want to tell you all about is, listen, it wouldn't be me if I didn't talk about H-1B lottery. So the H-1B lottery is currently open and has been open for a little bit now. It will close on March 24th at noon Eastern Standard Time. The fee to enter the lottery, the government filing fee, is $215. It is not too late to get yourself registered. I would not recommend waiting until 11:30 a.m. Eastern Standard Time on March 24. Technology always has its glitches, as does the H-1B lottery process, although it's been smoother this year than in past years. But the lottery is still open. You still have time to get yourself registered, so keep that in mind. And the last thing I want to talk to you all about this morning, I get a lot of calls with respect to individuals that want to apply for their green cards here in the States. And they call me and they say, I want to apply for national interest waiver, or I want to apply for, an outstanding ability green card. And a lot of these people are calling because they don't necessarily want to be tied to an employer, which I understand that. That's fine. But so two things, really. The first is that you can still have an employer sponsor an EB-1A, extraordinary ability, or an EB-2 national interest waiver. So just because you can self-petition doesn't mean that your employer cannot. So there's that. The other thing I want to talk about really sort of very broadly is when people come to me and they say, well, here's what I want. One of the things we always talk about is, do you have documents, right? Like, you can say to me, I'm the best thing since sliced bread. I'm curing whatever disease. I'm making whatever international process or national process way more efficient. You can say all the things, but if you don't have the documents to back up what you are claiming, then the Immigration Service is not going to approve you, right? So very broadly, the extraordinary ability thinks backwards, and the documents that they want look backward. They look at what you have accomplished in your field. National interest waiver, very broadly, looks forward. What will you do that will have national importance if the green card is issued? So think of extraordinary ability as looking backwards. National interest waiver looks forwards in terms of what you have done and what you will do. But either way, whether we're looking backwards or forwards, whether we're looking at EB-1A or national interest waiver, we need a clear explanation of what you want to do in your industry. We need a clear explanation of what your industry is. We need a clear explanation of what makes you amazing at what you do or what you want to do. Who will you help? And why is what you do and who you want to help important? Those questions need to be answered. The way we answer them, the way we position the application, again, one looks backward, one looks forward. But those are the basic questions that I will always cover in a consultation with someone. But they're also required to be covered in the application. So it is one thing to read the requirements online and say, oh, I think I meet that. But do you have the documentation that backs it up? And two, can you really sort of tell me what you do such that I can relay that to the Immigration Service? So I wanted to kind of bring that out because I take several calls each week on EB-1A or national interest waiver, and people are super interested in both of those categories. But a lot of times people aren't sure what they need to bring to the table by way of documentation and presentation and that sort of thing. So I thought that would be helpful for you guys to hear. And that is all I have for this Monday morning. Again, I'm Carol Williams. This is Beyond the Soundbite. If you have any questions about your immigration cases, or you're just not quite sure where to go, or you're pretty sure you want to enter someone in the H-1B lottery, I need you to make that decision like yesterday. But we're more than happy to help you with that, and we're here. So let us know. But have a wonderful rest of your Monday.